Okay friends, we now discuss about rule 10A of GDS conduct and engagement rules. Procedure rule 10A tells about procedure for imposing minor penalties. No order imposing any of the penalties specified in class 1 to 5, that is minor penalty of rule 9, shall be passed on GDS except after the Sevak is informed in writing of the proposal to take action against him or her and of the allegation on which it is proposed to be taken, and given opportunity to make any representation he or she may wish to make, and such representation, if any, is taken into consideration by engaging authority. If it is a minor penalty, the procedure for imposing it will be the GDS must be communicate about the proceedings to be initiated against him, and on what allegation the proposal is going to be imposed, and if any representation must be submitted by the GDS, it must also be heard and considered. Only then the minor penalty can be imposed. Okay, then rule 10D tells about procedure for imposing major penalty. Procedure for imposing major penalty. Major penalty is detailed in class 6 to 9 of rule 9, and it can be imposed on GDS. No order imposing penalty specified in class 6 to 9 of rule 9 shall be passed on GDS except after the Sevak is informed in writing of the proposal to take against him or her and the allegation on which it is proposed to be taken, and given opportunity to make any representation he or she may wish to make, and such representation, if any, is taken into consideration by engaging authority, provided that the major penalty shall not be imposed except after an inquiry in which he or she has been informed of the charges against him or her and has been given a reasonable opportunity of being heard in respect of those charges. In addition to minor penalty, an inquiry must be made to the GDS in respect of allegations on which the proceedings are initiated. Inquiries must for imposing major penalty. Whereas for minor penalty, inquiry is not compulsory. At the discretion of the discretion of disciplinary authority, and on request of aggrieved GDS, when he or she requests for an inquiry under minor penalty, it may be considered by the disciplinary authority for holding an inquiry. It is not compulsory in case of minor penalty. Holding an inquiry is not compulsory for minor penalty, but holding inquiry is very much essential while the proceeding is going to be entered with a major penalty. Provided further that where it is proposed after such an inquiry to impose upon him or her any such penalty may be imposed on the basis of evidence adduced during the inquiry. Then rule 10C, what are the records should be made while proceeding the inquiry. The records of proceeding shall include the copy of intimation to Sevak of the proposal to take action against him or her, a copy of the statement of allegation along with a list of evidence in support of thereof communicated to him or her, his or her representation if any, the record of inquiry proceedings along with the inquiry report of engaging authority or inquiry officer if any appointed in a case where a formal inquiry is necessary, the representation of any of the Sevak on the inquiry officer's report, finding on the engaging authority in respect of allegation, order imposing the penalty. These must be recording documents while recording these records must be prepared and maintained while a proceeding is on the way. And rule 10D Inquiry has to be conducted even if GDS accepts the charges. In case where major penalties to be imposed by engaging authority, the purpose of holding inquiry in such a case is primarily to give the GDS adequate opportunity to defend him or her. In case the charge is accepted by him or her unconditionally, there would obviously be no need for inquiry for imposing major penalty. Okay. Then Rule 10E. Normally, there is no need for conduct of an inquiry or imposing minor penalty to GDS. As I told earlier, there is no need for conducting an inquiry or imposing minor penalty to GDS. However, when a minor penalty is to be imposed under Rule 10, it is up to the discretion of disciplinary authority to decide whether an inquiry should be held or not in case of a request by delinquent GDS received by the disciplinary engaging authority. The implication of this rule is that on receipt of representation of delinquent GDS concerned on the imputation of misconduct or misbehavior communicated to him or her, the disciplinary engaging authority should apply its mind to all facts and circumstances and reasons urged in the representation for holding a detailed inquiry and form an opinion whether an inquiry is necessary or not. In case where delinquent GDS has asked for inspection of certain documents and cross-examination of prosecution witnesses, the disciplinary or engaging authority should naturally apply its mind more closely to the request and should not reject the request solely on the ground that inquiry is not mandatory. If records indicate that, notwithstanding the point urged by delinquent GDS, the disciplinary or engaging authority could, after due consideration, come to the conclusion that an inquiry is not necessary. It should say so in writing, indicating its reason, instead of rejecting the request for holding inquiry summarily without any indication that it has applied its mind to the request. As such, an action could be construed as denial of natural justice. What it's saying is that it is not compulsory for a minor penalty to holding a formal inquiry, but in case if a delinquent GDS requested the disciplinary or engaging authority for an inquiry against the charges made over, then it is up to the discretion of engaging authority to hold an inquiry or for inquiry or not. If we and it must not be rejected summarily that it is so. That formal inquiry is not at all needed for a minor penalty, and if it justify that the inquiry is not needed even after the request placed by GDS, if requested by GDS, then it must be communicated in writing instead of rejecting the request for holding inquiry summarily without any indication that it has applied its mind to the request. That is, it must be communicated in writing without rejecting it the request, which is against natural justice. Okay. Rule 10F, procedure for imposing penalty after discharge. If an GDS get discharged but penalty pending, imposing penalties pending, then the department proceedings under Rule 10, if instituted while a sevak was an engagement, shall after the discharge of sevak on attaining the age of 65 years be deemed to be proceedings under the rule and shall be continued and concluded by the authority by which the proceedings were commenced in the same manner as if the sevak has continued engagement, and in such case the function of disciplinary authority shall be only to reach a finding on the charges and to submit a report recording its finding to the President, and final decision on such a report shall be taken in the same manner as in the case of review petitions of sevaks addressed to President, and no appeal shall lie against such decision. What is that mentioned? What is the meaning is, that is if a Rule 10 inquiry is instituted and the sevak was get discharged, then the disciplinary authority or engaging authority must proceed the case as usual, as the GDS was on duty, and must report its finding on the proceeding to the President or government, and he cannot take any impose penalties on the discharged GDS, and such thing will be and the final decision on such report will be taken by the government or President as per the Conduct rules. The President reserved to himself the right of withholding group insurance amount, security amount, post-engagement benefit like ex gratia, gratitude, GDS gratuity, and severance amount of GDS by ordering recovery from this amount in case of Sevak is found guilty of grave misconduct and negligence during the period of his engagement. If a president reserve himself, that is, he has the right to withhold. The president has the rights to withhold the group insurance amount, security, severance, or gratuity, GDS gratuity from the Sevak if the Sevak is found guilty of any grave misconduct or negligence during this period of engagement. For the purpose of this rule, department proceedings shall be deemed to be instituted on the date on which statement of charge is issued in the Sevak, or if the Sevak has been put off duty, and the date on which he or she had been so put off for the purpose. Rule 10G of GDS conduct rules tells about procedure for disciplinary proceedings after discharge. Rule 10E what tells about? Rule 10F tells about procedure for imposing penalty after discharge. That is, if GDS get discharged, then how can the penalty be imposed? Is told in Rule 10F and Rule 10G that how can the disciplinary proceedings can be proceeded after discharge. The department proceedings under Rule 10, if not instituted and the GDS is discharged attaining an age of 65 years and his or her terminal benefits have not been released on the ground that department proceedings under Rule 10 were proposed to be instituted shall be instituted after discharge of the Sevak and attaining the age of 65 years and be deemed to be proceeding under the rule and shall be continued and be concluded by the authority by which the proceedings were proposed to be instituted, and in such case the function of the disciplinary authority shall be only to reach a finding on the charges and to submit a report recording its finding to the President, and the final decision on such a report shall be taken in the same manner as in the case of review petition of Sevaks addressed to the President and no appeal shall lie against such a decision. Provided that departmental proceedings are not instituted while the GDS was in engagement before his discharge, shall not be instituted save with the sanction of the President, shall not be in respect of any event which took place more than 4 years before such institution, shall be conducted by such authority and in such place as the President may direct and in accordance with the procedure applicable to departmental proceedings in which an order of dismissal from engagement could be made in relation to GDS during his or her engagement. The President reserved to himself the right to withhold any security deposit, security amount, post-engagement benefit like GDS gratuity and severance of amount of a Sevak by ordering recovery from this amount in case of a Sevak is found guilty of grave misconduct or negligence during the period of his or her engagement. For the purpose of this rule, department proceedings shall be deemed to be instituted on the date on which the statement of charge is issued to the Gramdak Sevak or discharged Gramin Dak Sevak, or if the Gramin Dak Sevak has been placed under put of duty from an earlier date on such date, and judicial proceedings shall be deemed to be initiated in case of criminal proceeding on the date on which the complaint or report of a police officer of which the magistrate takes cognizance is made, and in case of civil proceeding on the date of the plaintiff is presented in the court. Okay friends, we say provisions of Rule 10 in which it cannot be applied in the next video.